My Lord, in meeting that sentence, my Lord, we want to persuade you that each act of disobedience be treated separately. And each act of disobedience should attract maximum sentence, custodial sentence. My Lord, before, in respect of the orders made by Justice Aburili, there were two orders which were made, both which were disobeyed. One, to release the petitioner.
I read about it yesterday.
I'm allowed, on that account, I invite your Lordship to award a sentence of 6 months. I plead with the court, award a sentence of 6 months. Or meet a sentence of 6 months. In respect of the non-appearance of the petitioner in court yesterday, because there's a specific order for the petitioner to appear in court yesterday, another sentence of 6 months. My Lord, in respect of the orders that you made for the appearance of the petitioner yesterday and today, there are two separate and distinct acts of disobedience. Each should attract 6 months. The respondents were supposed to appear before your Lordship yesterday. They did not appear. That should attract 6 months. They were to appear today. They have not appeared. 6 months, my Lord. Mr. Muguna was to appear today. 6 months, my Lord. There was an order that Mr. Miguna should not be removed from the jurisdiction of the court in any circumstance. That has been disobeyed, my Lord. That should be 6 months. There was an order that the advocates should be given access to the petitioner. That was not given. Instead, we were clobbered very badly. That should be 6 months. So cumulatively, for each respondent, they should serve a sentence of 3 years. That is, the 6 months sentence should not run concurrently. They should run consecutively. And the reason why this sentence is necessary are first the reasons advanced by your Lordship yesterday, including the citation of Article 10 of the Constitution, the rule of law and Bill of Rights. These are specific principles and values that are very core to our Constitution. My Lord, under Article 20 of the Constitution, it says the Bill of Rights applies to all law and binds all state organs and all persons. So it is not an idle proposition to demand a safe sentence once there has been a violation. Article 21, Sub-Article 1, it is a fundamental duty of the state and every state organ to observe, respect, protect, promote, and fulfill the rights and fundamental freedom in the Bill of Rights. My Lord, in Article 238, which relates to national security organs, principles of national security, My Lord, Article 238, 1 and 2B, and if I may just read 2B, are significant. National security shall be pursued in compliance with the law and with utmost respect for the rule of law. This is directed to the all security organs, that there must be utmost respect to the rule of law. In fact, I don't find anything in the Constitution where that a similar principle is directed to any state organ more than it has been directed to security state organs, national security organs, rather. And in relation to what Senior Counsel Dr. Hamino has just said, Article 239, sub-article 3, is relevant in terms of how the police should carry out their duties without, which must not be done in a partisan manner. And then similar provisions are found in Article 244 of the Constitution in relation to the Bill of Rights and the rule of law. The reason why I'm saying all this is that these are things which are within the knowledge of the three respondents. They cannot carry out their duties without being alive to these provisions of the Constitution. There's also the provision that they must subscribe to the oath of office as contained in the Constitution. And my Lord, you'll find on those oaths of office for state organs, including the one for the first respondent, they require fidelity to the Constitution and the law, that they cannot assume office before they subscribe to that oath. That is how so fundamental is the question of Bill of Rights. And to that extent, my Lord, we are saying that a stiff sentence, custodial sentence is appropriate. And my Lord, if I may just crystallize what my senior counsel, Dr. Hamino, has said, I think there should be a specific order that they report to committee prison in the next 24 hours. I think we better be specific so that it's not in doubt, that they report to the committee prison by 2 o'clock tomorrow. And the officer in charge of committee prison be directed to receive them. And in there, I think they will find appropriate accommodation. They will not be put in a toilet. And just to crystallize again that during the period of sentence, they should not perform or exercise any authority or duty under the Constitution or under any other law. And my Lord, I just also want to demonstrate that this is not an idle affair. The President, Uhuru Kenyatta, together with the People's President, Raila Amolo Odinga, signed a communique which was made public. That handshake had some bearing and accountability. Which was made public. That handshake had some bearing and accountability. The handshake is a very important thing. But they went beyond a handshake and said certain things which are very important. My Lord, on page 5, of this communique, they said they faithfully adhere to the Constitution and the law. And on page 7, which is more important in this regard, and this is a word coming from the chief executive in the country, together with Raila Amolo Odinga. Kenyans must have their human and civil rights respected and enforced. My Lord, they are not just saying respected. They must be respected and enforced, which is what your Lordship is trying to do. This is what Uhuru Kenyatta is saying. There is no Kenyan whose rights should be compromised, no matter the interest against them. Kenyans have struggled hard for these rights. This is what Dr. Amino has just been saying. And they are not for anybody to take for granted. My Lord, again, this is a statement which weight must be placed upon, because it is coming from people in public office at the highest level, and therefore stiff sentence is justified. My Lord, this mess has now been exported to Dubai, in another jurisdiction. By a mess created by the respondents. Mr. Muguna is not in a position to know where next. So, my Lord, in addition to the order of making sure that Mr. Miguna comes back to the jurisdiction of the court, that at the expense of the state recoverable from the respondents, an officer of the Kenya National Human Rights Commission should be facilitated to travel to Dubai. To ensure that Mr. Miguna, as a citizen of Kenya, has his rights protected. My Lord, you've seen what the Canadians have done to Mr. Miguna here, and I understand even in Dubai, where they are showing compassion, the Kenya government is showing brutality. My Lord, additionally, that at the expense of the respondents, because the advocates for the petitioner have not been able to get full instructions. Indeed, at some point, Mr. Harvey had to swear affidavits on behalf of the petitioner. There are two counsels of the petitioner's counsels. And more importantly, Madam Julie Soweto and Mr. Harvey, who is the advocate on record, should be facilitated to travel to Dubai. To secure the interest of the petitioner. And my Lord, these sentences will constitute a rich history for this country. My Lord, yesterday you said words which would almost come immortal. No immunity to impunity. And today we repeat those words and say impunity must be punished. Lord, in the cases of Zuma that you cited in your ruling, my Lord, you'd find that the courts were very persistent. They didn't reach that position through any one proceedings, but the courts and the people of South Africa were persistent to bring to account the highest office in the land, to wit, the President of the Republic of South Africa. My Lord, in this regard, we are dealing with very junior officers in the order of things. Mr. Matiani has never been elected by anybody. And he can decide whether you sleep at the airport for 72 hours. He is told to come to court. He doesn't come. So, my Lord, you should not blink an eye in sending this character to committee for 3 years. My Lord, in sentencing the Director of Immigration, my Lord, I'd ask the court to look at his conduct in relation to the deportation of Mr. Miguna. That we are in this situation because of the Director of Immigration. The first sin was committed by him. My Lord, the Inspector General should be stiffly punished because through his office, many ordinary persons are brought before the courts, in the words of Mr. Mutinda, to be processed. But I don't think we don't process people in the courts. So what is good for the goose is good for the gander. His time has come. Mr. Boynet's time has come. And, my Lord, finally, there's a perforated passport which has been deposited in court in these proceedings. The court should order that a passport be immediately a Kenyan passport, valid passport. And in fact, this is a repetition of the order of Justice Muita. Be issued and given to Counsel Mr. Harvey to hand over to Mr. Miguna. And my Lord, just with a light touch, so many years ago there was an Ethiopian who suddenly every Kenyan thought was dead and Kimathi. So he left Ethiopia.
General Madenge.
Yeah, General Madenge. And he was suddenly in the territory of Kenya, received as a hero, only for the government of Kenya to realize that this was an Ethiopian. But for this particular individual, they gave him all the travel documents. He was not a Kenyan. It was purportedly that he was a Kenyan by birth. And also take into judicial notice that whenever the respondents wants to arrest or serve any individual, they do it with gusto. There's Mr. Jimmy Wanjigi here in court. And just to serve a summons, he was stopped on a highway, flying squad. And one of the officers who was in that flying squad is the fifth respondent, Mr. Said. So if he can do this, perform such miracles, he should be able to perform them on his bosses, finding them. And that will be all, my lord.
May it please your lordship. Well, that is all for the petitioner. If you could allow me, Mr.